Welcome to Crime in Court. This is the 1996 Menendez brothers retrial, and we are on part 21 of the state's case, and we are on the second part, or as I call it, part B of to not get confused with the state's case. So this is part B of Jamie Pisarcik's testimony, who is Lyle Menendez's ex. So that is where we are. I kind of took a little break in between. I didn't mean to take a break in between her testimony, so I apologize on that, but I just was kind of feeling burnt out. I have, fibromyalgia, ankylosing spondylitis, anemia, all sorts of things wrong with me. And that's just to name a few. So I just was feeling a little burnt out, needed a break. So I apologize, but I am back and I am ready to roll. So let's, without further ado, get started. Please hit that like button. And where we left off last time, we were in the middle of cross from Lyle's team. This is all for the jury to consider for only Lyle, not for Erik. So Erik's team is not going to be doing any cross on this particular witness because it's Lyle's ex and there was nothing really relevant that they wanted to get out of Erik with this witness, but all of it's with Lyle, which is confusing because there's one jury as opposed to last time in the 93 trial. There were two juries and one for each witness. They could send one jury out of the room while they displayed evidence, while evidence came out about one witness or one defendant and not the other. So that's how they dealt with it in the first trial. This trial is different. How do you, as a juror, separate, well, I heard Lyle did this. Does that, how do I separate that from them being one and the same? So that's an issue here. A lot of differences that we're seeing, discrepancies in that regard, where it's kind of, not helpful for the defense when the judge made so many different decisions this time around. So we left off, they cut from testimony because Jamie Pisarcik started talking about what she described Lyle telling her about images of a certain nature, rhymes with corn, and those images were somehow related to the live entertainment business and something along those lines. And they cut to send the jury out, and then it was just argument between the attorneys, and they were talking about the fact that this wasn't turned over in discovery. This is the first time I'm hearing about this. So now they had their argument. Now they're back in front of the jury. And here is a continuation of Jamie Pisarcik's testimony with Lyle's attorney's questioning. Sorry, I'm trying to do two things at once. With Lyle's attorney's questioning. As you can see on the screen, I have Judge Stanley Weisberg, which is that way. It's hard to do backwards. That way. And then below me, I have the attorneys for the state and for Lyle and for Erik because they have two separate sets of attorneys. All right, so let's get started. The jury comes back. The court says, all right, let's see. Where's your witness? Where's the witness? Ms. Nahara for the state says she's outside. I thought Detective Zoeller was. The court says, all right, you may continue your cross-examination. Ms. Towery for Lyle is going to be doing the question or continue her questioning. She says, thank you, Your Honor. Ms. Pisarcik, you first spoke to the prosecution with respect to this case on October 28th, 1992, didn't you? Yes. And that's when Ms. Bizanich and Detective Zoeller came to your home and spoke to you. Is that correct? Yes, correct. And about a month later, you gave the sworn statement that we have discussed at various times to Ms. Bizanich and Mr. Kuriyama and Detective Zoeller. That was recorded and transcribed. Is that right? Correct. And in November of 1993, you gave another statement to Detective Zoeller, did you not? November 1993? Yes. Yes. And police reports were prepared with respect to your first statement and the 1993 statement, correct? Correct. And you got to see copies of those, didn't you? Yes. And you also saw a copy of your sworn statement given in 1992, didn't you? Yes. As a matter of fact, you have a copy of that, don't you? Correct. And you testified at the previous trial of this matter, didn't you? Yes, I did. And when you testified at the previous trial, you also testified that you had reviewed your sworn statement given in 1999 for accuracy, didn't you? Yes. And you did do that, didn't you? Yes. And you've also reviewed that sworn statement since your testimony given in this trial in 1993. Is that right? Yes. I have recently reviewed it. Yes. And you also met with the new prosecutors, Ms. Nahara and Mr. Khan, or perhaps just Ms. Nahara, I don't know, a week or so ago. Is that right? Yes. On October 12th, 1995. Yes. And by the way, if you are following along, sorry, I didn't mean to interrupt so abruptly, but if you are following along, which there's links in the description below, you can grab the transcripts. We are on November 1st. I am on page 104 at the moment. All right, so she asks, Ms. Towery asks, and you also met with the new prosecutors, Ms. Nahara and Mr. Khan, or perhaps just Ms. Nahara, I don't know, a week or so ago. Is that right? Yes. On October 12th, 1995. Yes. And who did you meet with when you met with the new prosecutors in this case? Both Ms. Nahara and Mr. Khan. Okay. And was Detective Zoeller present as well? Correct. And at the time you met with the prosecutors on October 12th, 1995, were you taking notes? Yes. Was Detective Zoeller taking notes? Yes. All three of them were taking notes? Correct. And that was a lengthy meeting, isn't that right? Several hours, I believe. What the hell are you talking about for several hours? And where did that occur? I believe it was here in this building. They called you up and asked you to come and speak with them? Yes. And you did so. Correct. Have you received a copy of the police report that was prepared with respect to that meeting, that is October 12th, 1995, to review? No, I have not. Now, in all those meetings that you've had with the prosecution, when was the first time that you told anyone about live entertainment having these ties to the industry that rhymes with corn? Well, I believe that it was recently, but I have had those documents of my testimony and have reviewed them since, them being in my possession. And to tell you the truth, having that ability to review that has brought back my memories that I have not obviously remembered from the first time I was asked those questions. Mhm. Yeah, all of a sudden your memories just come back to you years later. So, you have taken the time to review your testimony and try and remember after you testified whether or not what you said was accurate or not. Is that right? Yes, in order to be prepared. And when you reviewed your testimony that you gave both at the trial and the sworn statement, you didn't say anything about these ties with live entertainment, did you? No. I don't remember exactly what I stated when I stated it, but I do remember Lyle saying that. I'm not asking what your recollection is today. I'm asking you, you didn't testify to that previously, did you? If it's not in the testimony, obviously, I didn't remember. Convenient. My question is, did you testify to what your recollection was at that time? Did you testify about these industry ties of live entertainment at the last trial? No, I did not. Whoops, I didn't mean to click on my mouse there. Um, no, I did not. So she never testified about this statement here that Lyle told her about these ties to the industry that rhymes with corn, with her dad's business or his dad's business. And you didn't tell Mr. Kuriyama and Ms. Bazanich and Detective Zoeller in your sworn statement that was transcribed about these ties of live entertainment at the time, did you? No, not until after reviewing it that I, obviously remembered. Did you tell them at that time? I guess not. No. In fact, what you told them at that time was that Lyle made it known or made it sound like it was the mafia or, quote, that's what I was believing at the time, that it was somebody after his father. That's what you said, isn't it? Yes, that's my statement. Then you were asked why you believed it was somebody after his father, and you said business reasons. I don't know. That's what you said in 1992, correct? Correct. And that's what you read in the transcripts when you reviewed it. Yes, it is. Now, when is the first time that you told someone connected with the prosecution that now you remember that Lyle Menendez said something about live entertainment having ties to the corn industry? Ties to corn, I'll just say. Well, I believe in the last time I spoke with them after having the opportunity to review my previous statement. So that would be October 12th, 1995 meeting that you had with the three of them, correct? Correct. So all of a sudden, this new prosecution team comes on in, and she has another version of her story, something she suddenly remembers that she forgot in previous statements and testimony, never said before once to anyone. Uh huh. And if that does not appear anywhere in the police report that was prepared with respect to that meeting, is it still your recollection that that was when you told them that? I believe so. They just didn't write it down? Well, I don't know, but that is what I remember. And when you said that, were all three of these prosecutors, excuse me, both of the prosecutors and Detective Zoller present? Again, I don't remember. Your Honor, I'd asked to approach briefly. The court says on this subject. Ms. Towery says yes. The court says later on we'll do it now. Later on we'll do. Oh, later on we'll do it, he says. Sorry. Later on we'll do it. She says, all right. Now, just so that we all understand, the very first time you ever told anyone about the corn ties is when you told them, correct? When you told them on that in that interview. Yes, when I was talking to them, yes. And that was on October 12th, 1995, correct? I think so, yes. Now, you moved to California in 1989, and did you say November? Is that right? Either late October, early November. And you moved here to help Lyle because he was having a difficult time, correct? Yes. And you came here to help him out emotionally, correct? Well, emotionally, yeah, for a lot of different reasons. And you also wanted to live here in California. Would that be part of it? I had been out to California before, obviously, and it was a place that I would like to reside, yes. And Lyle was going through very difficult times in September, October, November, December, and January, wasn't he? Yeah, he was pretty much out of control. And you were trying to help him, correct? Yes. And he was having great emotional difficulty during that time, is that right? I don't know how you would describe great emotional difficulty. He was very scattered. He didn't seem, he seemed like he asked for help. He help in trying, he had never balanced a checkbook before, very basic day-to-day things that he asked for help. And you came to help him? Yes. And when you were writing to him when he was in the jail, you wrote to him about the difficult times that he was going through, did you not? Uh-huh. May I approach, Your Honor? Yes. Showing you a page of a letter that's been marked as Exhibit 377 at the last trial, I think. Next in order is 154. Is that right, Your Honor? He says 154. And you were shown this letter previously, I think. I'll just ask you to take a look at it again. The whole thing? Just the paragraph. Okay. This letter was dated, Ms. Towery says, when was that letter dated? April 20th, 1990. Is that a letter you sent to Lyle Menendez after he was arrested? Yes, it would be. And that indicates that he was going through a difficult time during the months that I mentioned earlier, correct? Correct. Ms. Nahara says, I'm going to object as hearsay, Your Honor. The court says, sustained. The answer is stricken. Why? It's from a party opponent, right? So it's the defendant. His statement should be able to come in. So I don't know, whatever. He says sustained. The answer is stricken. Ms. Towery says he was going through difficult times during those months, correct? Yes. Now, you lived with him at the Marina City Club from November to January, right? Correct. And I think you said in your direct testimony that that was a purchased condominium. That wasn't a purchased condominium, was it? Well, no, he paid rent for it. It was a rented apartment. Yes, yes, it was. And then you moved out in January, is that right? Correct. And when you moved out, did you break up with Lyle Menendez? Yes, in a way. Lyle was again kind of out of control, spending a lot of money, and wanted to take a trip to Vale and wanted to pay my way to go to Vale. And at that point, I just said that the relationship can't continue this way, and he wants to take you on a free vacation to Vale. Why? Can it continue that way? Like what? And I really didn't want to accept the trip. And he went off to Vale. And at the time that he was there, proceeded to leave. So you broke up with him? Yes. Did you give him his ring back? No, not at that time, I don't think. Did you have his ring then? Yes, I did. How did you get it back when you returned it to him in the spring of 1989? I don't think I had the ring then, actually. I don't remember. So you didn't have the ring. I don't think I got the ring back. I don't remember if I had it during those several months that I was here before Lyle went to jail. I did get it back when he went to jail. Perhaps I'm confused. I thought that you returned the ring to him in April or the spring of 1989 when you broke up with him. Is that right? Correct. Did he return it to you between that time and January of 1990 when you broke up with him again? I don't know if I had it, or I don't know if I had. That's what I'm trying to say. I don't think I had it during that period of time after his parents died. I don't recall if I actually had it. I don't think I did. I don't think I got the ring back until he was in jail. Okay. So you're saying that you did break up with him when you moved out, correct? Yeah. And then your relationship resumed after he was arrested in March. Yeah, again, during that January through March period, we did see each other and we did date, but then, yeah, it obviously brought us back together when he was put in jail. And you're saying that the reason that you broke up with him was because he was out of control. Well, he was just doing a lot of things that I was obviously not comfortable with, like going to Vail. I don't understand why that's an issue, but okay. Okay, like a trip to Aspen when you didn't want him to pay for it, to pay for it. Is that right? Well, is that what you just said? No, that's not what I said. I said I did not feel comfortable going with him on that trip and having him pay for the trip. Hadn't he just given you a sob for a Christmas present? Yes. And you accepted that, didn't you? Yes, I did. So he gives her a car. She's totally cool with that. She's not okay with taking a vacation with him. Huh? And how much did that cost? I don't know. When did he give you the sob? It was a Christmas gift. Was it before Christmas that he gave it to you? Obviously, it was around Christmas time. I'm assuming it was on Christmas, but and he drove it up in a red ribbon around it. Is that right? Yes, it was at the Marina City Club. And Miss Towery says, "May I approach the witness, Your Honor?" Court says, "Yes." "I have a document that was previously marked as Exhibit 380. I've forgotten the next number. Is it 155?" Court says, "Yes." "Let me just show you this document." Okay. "Do you recognize that from having it in at a previous trial?" "No, I don't believe I do, but so you never saw that." "I don't recall seeing it." "What did?" Ms. Harris says, "I'm going to object to no foundation if she's never seen it before." The court says, "Well, I'm not clear as to whether or not she's ever seen it as an exhibit or never saw it before at all. So why don't you clarify that?" "Did you see it as an exhibit at the previous trial?" "I don't remember seeing it, no." Is that no or you don't remember? "I don't recall seeing that as an exhibit presented to me at the last trial." Okay, so it wasn't presented to you. Object misstates the evidence. The court says it's argumentative as phrased. Ms. Towery says, "Well, my question is, did you see that exhibit that I just marked as 155 in the last trial or not?" "I don't remember. You'd have to show it to me in order to refresh my memory." "I did show it to you just now. Does it refresh your memory?" "Well, I guess I don't remember seeing it in. If you could show it to me in written testimony, that would help refresh my memory." Okay. You have no idea how much the sob that you received cost. Is that correct? No, Lyle bought it for me as a gift. It was a nice car, wasn't it? Yes, it was a used Saab. How old was the car, if you know, when you received it in December of 1989? I think it was an 85 or an 86. I can't be sure though. Do you still have that car? No, I do not. How long did you keep it? I kept it through June of, I believe, June that year. So she didn't even keep it? Why did she get rid of it? And what did you do with it in June of that year? Well, Lyle and I both discussed selling it. It was having some mechanical problems, and they were expensive mechanical problems that I really couldn't afford to keep that kind of maintenance up, and I sold it. I traded it in. Sorry. So you traded it in? Yes. For what kind of car? A Mazda. A Mazda? Correct. Was it a Mazda Miata? Yes, it was. And now, how did you get, uh, and how much money did you get it for it when you traded it in? I don't remember at the time I traded it in, and I was making payments on the car monthly. On the new one that you got? Yes. The Miata? Yes. May I approach the witness? The court says yes. Let me show you a portion of your testimony from the prior trial and ask you to read this portion of it, please. The witness says, okay. May I ask what line you're referring the witness to? Ms. Nahara says. Ms. Towery says lines 4 through 14. Ms. Abramson says page cite, just for the record, 22467. Okay. Ms. Towery says, have you reviewed that? Yes, I have. Does that refresh your recollection as to whether or not you have seen the item that's been marked as Exhibit 155 before? Yes, it does. Thank you. Were you shown that at the previous trial? Yes. And when you saw it at the previous trial, you described it as a check made out to Toyota of Marina del Rey. Ms. Nahara says, I'm going to object. There was no foundation laid in the previous trial. We'd object. There's no foundation now. Court says sustained as to what she might have said before, unless she did then, or has now a recollection of what that represents. Ms. Towery says, the check before you is dated right about the time Lyle Menendez gave you the sob for Christmas, isn't it? Ms. Nahara says, I'm going to object. Calls for hearsay. Sustained. Ms. Towery says, now, when you testified at the previous trial, you explained why you left the Marina City Club apartment in January of 1990, didn't you? Yes, I believe I did. And at that time, you explained that you left the apartment, quote, because it was difficult for me to handle the emotional things Lyle was going through. Is that right? That's very true. Yes. Is that still true? Yes, it is. In addition to your not wanting him to pay for a trip to Aspen, correct. Not only pay for a trip to Aspen, but that would be the part of the emotional things Lyle was going through, spending a lot of money, just things that I did not agree with, be that emotional as it were. So it was hard for you to deal with his emotional reaction to things, is that right? It was hard for me to deal with the way he was living his life. So you left him. Yes. Before you left him in January when you were helping him to deal with these emotional problems he was having. Right. You also helped him manage his finances, didn't you? Well, I had helped Lyle, I guess, manage his finances in a way that I helped him manage his checkbook. He never writes checks down. He would just he would just write checks and not keep a record of them. And so, yeah, I mean, the reason I came out here to California was really to try to help him get his life together and try to get him back on track. So he had never balanced a checkbook and he didn't know how. Is that right? Well, from my experience with him, no. I don't know previous to that. So he wasn't great at handling money or keeping track of money. Is that fair? Yes. So that's a good point that they're making that, even uh, they want to say that, they were just spending money frivolously. Well, look at this. Like, he doesn't know how to even balance his checkbook. So, how can you expect that he would have been responsible with money if he's never been responsible with money his whole life because it's always been accessible to him? So, that's a fair point. And as he had been before his parents died, he continued to be generous with you. Is that right? Yes. And he gave you money when you needed it after you came to California, didn't he? When I first came to California, I started to look for a job and I didn't have one right away. I did obtain one in, I think it was mid December, but no, I came out here after having played in Israel in that tennis tour and did not have a job. So, yes, he did help me out until I got on my feet. So, he helped you with your expenses? Correct. And he was generous with you when you came to California, correct? Correct. And he bought you the Saab. Yes. I presume he didn't charge you rent for living at the Marina City Club, did he? No, not for that month or two that I was there, correct. From November to January, correct. And you also helped him in other ways. In addition to helping him with his emotional difficulties and helping him with his difficulty in handling finances, you also gave him advice on the restaurant that he bought, didn't you? I don't know if you would consider it advice. I considered it my opinion. I have no restaurant serious background to call upon to really advise him. But yeah, it was an opinion. I had worked at restaurants before. I knew what managers were paid, that type of thing. But as far as studying restaurant management, I had no experience. So if you would call it advice, I guess it was. So you had more experience with restaurants and you helped him out with that as well. Well, if he asked me or he obviously shared with me what he was doing and things like that, what salaries he was paying people and those types of things. Okay, may I approach, Your Honor? Yes. I have a document that was previously marked as Exhibit 382. I'll mark it as 156 for identification. Court says all right. Story continues. Is that something that you were shown in the previous trial? Ms. Nahara says, I'm going to object to whether or not she was shown in the previous trial. Sustained. Ms. Towery says, is that a document that you recognize? Yes, I wrote this. It's a letter from you to Lyle Menendez. Yes. And was that also actually, it's a card, isn't it? Yes, correct. With a balloon on the front. Was that something you wrote to him when he was in jail or not? Let me see the date. Ms. Nahara says, I'm going to object as irrelevant. The court says, overruled. The witness says, I really don't know because it doesn't have a date on it. Ms. Tower says, all right. It is something that refers to the restaurant that he purchased, doesn't it? I really didn't have a chance to read it. I just kind of skimmed it. All right, let me ask you to just read out loud this portion, to this portion, if you would. Ms. Nair says, I'm going to object to anything referring to the content as hearsay. Sustained. Did you give Lyle Menendez advice on the restaurant that he purchased after the purchase of it? Well, I'm sure that Lyle and I had a lot of conversations about him handling the restaurant, possibly losing the restaurant because he was going through some difficult managing. So, yeah, I'm sure I gave him my opinion. Again, if you would like to call that advice, I wasn't an expert in restaurant management, however. Okay, who was Erik Tam? Erik Tam was a high school friend of Lyle's that he was going to employ, or maybe he did employ, I don't recall, to be his restaurant manager. And when was that? When was Lyle going to employ Erik Tam to be his restaurant manager? Objection irrelevant and calls for hearsay. Sustained. Did you give Lyle advice on how much he should pay Erik Tam? Objection irrelevant. Overruled. I'm sure I probably, when Lyle asked me how much managers get paid, again, I had been employed in restaurants previously, so yeah, I'm sure I probably told him what I thought a manager should be paid. Did you tell him that you thought that he was planning on paying Erik Tam too much money? I could have, yes. Did you tell him that he shouldn't be paying more than $20,000 with a bonus if he produced? I could have in the letter. Yeah, that was obviously my opinion. That was your opinion, and you expressed it to Lyle Menendez. Is that right? Lyle and I had an intimate boyfriend girlfriend relationship. I'm sure we had a lot of conversations about this, not just in the letter. So there were other expressions of opinions in addition to what you put in this letter, correct? Possibly. She just said she was sure. Now she's saying possibly. Whatever. And you also told him that the restaurant had to come up with $100,000 by January or he would have to sell, didn't you? I obviously did, yes. And you said to him that he may not care, but you do very much. Is that right? Well, Lyle, as I said, was throwing around a lot of money and very wasteful at the time. As being his girlfriend and trying to help him get his life back together. Yeah, I mean, I would think it would be important to anybody if someone was throwing away a lot of money. So you thought that his friend Erik Tam was taking uh, too much money from him. Is that right? No, not necessarily. I believe that I felt that Lyle was probably paying him a little bit too much money. Okay. And you said not that Erik was taking from him. Okay. You told him maybe he should give Erik Tam a percentage or something and be a real businessman, didn't you? Obviously, I did if it's in the letter. Did you tell him to stop being someone that gets taken advantage of time and time again? It's possible if it's in the letter. Yes, I did. So you're upset with him because he's a nice guy. And did you tell him, and he's generous with money. And did you tell him not to argue with you that Erik Tam is his friend? Ms. Nahara says, I'm going to object at this point. This is irrelevant. Overruled, you can answer the question. The court likes the juice. He wants to hear the gossip that's going on between all these people. The witness says, "Would you repeat?" "I'm sorry." Ms. Towery says, "Did you tell Lyle not to argue with you that Eric Tam was his friend concerning the salary?" I think Lyle was a little confused at the time as to how much. I guess I was asking Lyle to consider Eric Tam as an employee and not a friend, so that because he was his friend, he was going to be paying him much more money than he would a normal employee. And you told Lyle that if Eric was really his friend, he'd he'd be glad to work for Lyle for peanuts, didn't you? That's what I would do, I guess. Wow. Okay, well, now we know what she does to her friends. And you told Lyle to find out what real friends are, didn't you? In the letter, yes. So she's pushing him to be more ruthless in business, basically, and to backstab his own friends. And you told him not to hire him if he couldn't distinguish between friends and employees. Is that right? Ms. Nahara says, "I'm going to object under Evidence Code 352. Court says overruled. The witness says, "I guess I considered that to be at the time a wise business decision." Ms. Towery says, "And you told him you wouldn't let him throw money away ever again. Is that right?" Well, I was trying to help Lyle, as I stated, that whole time that I was in California, and obviously I didn't do a good job of it. No, she didn't do a good job of helping him. Okay, and you told him you were sick of people, friends or not, taking advantage of him, didn't you? Objection, irrelevant, overruled. The witness says yes. And you said he'd better listen to you or else, didn't he? Objection, irrelevant, overruled. I guess I'd have to look at this. Yeah, I did. So she had to make sure that those were the words that she said. She wanted to figure out a way, probably, to get out of it. But it's in the letter that she's basically giving Lyle an ultimatum, and then she dumps him when he doesn't listen to her, I guess. Miss Towery says the reason you gave that advice to Lyle Menendez was because he needed it. Isn't that right? Well, as I told you before, I felt very uncomfortable with what Lyle was doing with his money, and that's one of the reasons why I left. Okay. And you don't know whether that letter was written after you left or before. Is that right? Yeah, I don't. But if you knew when Eric Tam was hired or was under consideration for being hired, that would help you date it, wouldn't it? Well, I wrote most of my letters, obviously, to Lyle when he was in jail, but I believe Eric was hired when Lyle was right after Lyle had bought the restaurant, but I don't know, I don't remember exactly. So obviously, Lyle wasn't in jail at the time that this letter that they're talking about was written. Now, after Lyle was arrested, you moved to Beverly Hills house, didn't you? The Beverly Hills house. Is that right? Yes. And you lived there with Eric's girlfriend at the time, is that right? Correct. And what was her name? Noelle. What was her last name? Terlesky. And also with Lyle's grandmother, Mrs. Menendez? Correct. And you recognize her here in court? Yes. And you didn't pay rent when you lived at the Beverly Hills house, did you? No. And then later, while Lyle was still in jail, the Beverly Hills house was being put on the market for sale. So you moved to the property in Calabasas, didn't you? Correct. And Noel moved as well. Is that right? Yes. Sorry, I had a cough there in the back of my throat. I had to clear my throat, so apologies. Uh, so she asks, and Noel moved in as well, is that right? Yes. And when did that happen? I believe that was probably maybe May or June when we moved up there. I think it was probably stayed up there through the summer. So you moved to the Calabasas house in May or June of 1990. I think so. I believe that's about the time frame. Now, at the time, had the main house in Calabasas been completed yet, or was it still under construction? Well, I guess there wasn't any construction going on at the time. There needed to be, I guess. It wasn't totally 100% complete, but there was no construction going on, and we were staying in the guest house. There was a guest house on the Calabasas property? Yes, correct. I didn't know that. It's the first I'm hearing about that. And when you moved to the Calabasas property, your boss at the time helped you move there. Is that right? I believe he helped me move out of there. His name was Jamie as well. He and several friends, yes. Ms. Towery says, this actually might be a good time to break. The court says, okay, we'll be in a recess until 1:30. Don't discuss this matter with anyone and don't form any final opinions about it. We'll resume at 1:30. And of course, there's going to be some argument here. All right, so the court says the jury has left. What was it that you wanted to approach about Ms. Towery? She says, well, I think that the witness's testimony, unless she's mistaken about when she disclosed this information to the prosecution, was in direct conflict with what Ms. Nahara indicated was the information that was obtained from the witness. Actually, we probably should have the witness excused for this. Please wait outside, the court says. The bailiff says, Your Honor, jurors are walking, so the jurors are now exiting the jury room. The court says, yes, go ahead. Mr. Hari continues, Your Honor, the witness's testimony was that she gave the information regarding this corn to the district attorneys at the October 12th meeting. She also indicated that notes were taken by Ms. Nahara and Mr. Khan at that meeting, which both directly contradict the information provided to the court and to the defense by the prosecution. And again, I'll look at the transcript of the witness's testimony yesterday in terms of the leading question, but I think at this point it's appropriate for the court to strike that testimony and instruct the jury to disregard it, that the prosecution intentionally did not disclose it to the defense and that it's not true. What's not true? That testimony. That she didn't tell that to the prosecutors or that Lyle Menendez didn't say it to her. Ms. Towery says, I think the only appropriate sanction at this point, because the damage has been done, is for the court to instruct the jury that the jury is to disregard that testimony and not to consider it true. The court says, all right, we have Detective Zoeller, who apparently was present during that interview. Does it show in his notes that this statement was made? Ms. Towery says no. Ms. Nahara says, Your Honor, the court says he's certainly available to impeach the witness then if it's not in his notes. Ms. Towery says, I asked the witness and she said it, even if it wasn't in his notes or report. Court says, that's fine. That doesn't make that true that she said it. It's just her statement. We have notes of other people who were present at the interview where it's not shown in the notes. And this point, I don't have any reason to believe that she did say it other than she testified about it here and she said it. You have at least one witness who's not a lawyer in this case who could testify about that conversation. So if you want to put him on the witness stand, you can do that. Yes. Ms. Nahara interjects and says, May I be heard briefly, Your Honor? I believe what I stated earlier, and I still stand by that statement, is I had notes about the conversation, and there was a note in there about corn. But I honestly do not have a note that says she told me that there was this statement. But I can honestly say that she didn't say that. I just didn't make a note of it. I can honestly say that she didn't say that. I just didn't make a note if she did say that and I don't remember it. But that doesn't mean it wasn't said. And I believe that's what I stated earlier, and that's what I stand by. I don't know. If she says she did, I'll go with her memory over mine. She's the one that said it. I knew. The court stops her and says, I'm not talking about what you remember at this point. We have Detective Zoeller who's here, and Detective Zoeller, you're still under oath. Do you have any recollection of that statement being made by the witness? Detective Zoeller says, No, I don't know. But at one point in the interview, I did leave the interview to move my vehicles. The court says, do you have any reason to believe it happened during that time? Detective Zoeller says, I have no reason to believe either way. The court says, were you present during times when she discussed this particular conversation with the defendant? No, Your Honor, Zoeller says. The court says, you weren't there at all when anything was discussed about what the defendant told her about why the parents' lives were taken. Detective Zoeller says, not that I recall, Your Honor. Ms. Towery says, I can indicate that Detective Zoller's report, and I think the court has a copy of it, doesn't reflect any discussion of that conversation at all. The court says, yes, I looked through it. So, at this point, what I'm presented with is a situation where the witness says that she said it and the prosecutor doesn't have a recollection one way or the other. Ms. Towery says, the other interesting thing, Your Honor, just to point out, the witness said Mr. Khan was taking notes during the interview also. We've never seen his notes. That's the problem. You're supposed to turn those over. The court says, do you have any notes? Mr. Khan says, no, I don't. The court says, did you take notes? Mr. Khan says, when she was being interviewed by Ms. Nahara, I was taking notes concerning her previous testimony and statements from the police report because she was Ms. Nahara's witness, and I was just catching up on our material. The court says, what do you mean you were not taking notes of the interview but just writing down? Exactly, says Mr. Khan. What? The court says, what? The court says what she had said before. So the question is, what do you mean you were not taking notes of the interview but just writing down what she had said before? He says exactly. Mr. Khan says, I was reading from police reports and taking notes from police reports, and I recall nothing. I do not recall recording anything that has not come out here in court. Ms. Abramson says, that's an interesting statement. What does that mean? Ms. Towery says, I think that begs the question. The problem is, things have come out here in court that were not disclosed to the defense. Apparently, now Mr. Khan had notes that weren't turned over as well, and we specifically asked for those. I asked Ms. Nahara when she handed me. The court says, Mr. Khan said his notes were not of the interview, but he was taking notes summarizing what he had said on earlier occasions, what she had said on earlier occasions, as I understand it. Ms. Towery says he also said his notes didn't reflect anything that hadn't come out here in court, which hedges that a tiny bit, Your Honor, and obviously things have come out here in court which were not discussed to the defense. For example, the witness's description of the scene at close range. She's never described the scene in at close range in the way that she described it here in court. Presumably, she either told the prosecutors that she watched the movie, subsequently watched the movie so she could describe the scene which wasn't disclosed, or the prosecutor showed her the scene from the movie, which is in and of itself suggestive in that the exact scene in the movie to which Lyle Menendez was referring wasn't necessarily clear according to her prior testimony. Yikes. So they were trying to shape her testimony to say certain things, make sure certain things came out. So none of that was disclosed to the defense. She just got on the witness stand and started talking about that as if she had seen it when we did 2 days ago. The court says, okay, when did she see the movie? Ms. Nahara says, my understanding, the court says, not what she said here, but when, to your knowledge, did she see it? The first time she saw it, says Ms. Nahara, I don't know. The last time, says the court. Ms. Nahara says, the scene was this morning. She saw that wait, what? This scene was this morning. She saw that, and I elicited that on direct examination, and I don't believe that's appropriate discovery, what we do to talk to a witness. And to Ms. Nahara said, showed her that movie? Ms. Nahara said, this morning, Your Honor. She showed her that scene in the movie that morning. Wow. The court says, okay, well, you didn't bring it out. It didn't come out. Ms. Nahara says, I thought I asked her about that. Court says, no, you didn't. Ms. Towery says, well, that's also, Ms. Nahara says, I believe she testified she had since reviewed the scene in the film, and I think I asked her about that. court says, no, you didn't ask her when she did that. Ms. Towery says, what I think Ms. Nahara is saying is that the prosecutor showed her that scene this morning. She didn't take it upon herself to rent the film and watch it, and that in and of itself is tampering with the witness or very borderline to that. Yikes. Witness tampering is now being accused here, potentially, because she was shown the scene. She didn't do it. And then she was asked to testify verbatim as to what she saw. The prosecutor shows her, not something that she recalled from Lyle Menendez telling her, not something she recalled from having seen the movie either with or without him, if she saw it at all before the conversation. She testified to something that the prosecutors gave her this morning. The court says, okay, that's clearly something that can be brought out in cross-examination, and I assume that it was something that you would explore with the witness. It seems to me as fair as reference to the corn connection and the witness's testimony that she told the prosecutors about it during the October 12th interview, and the prosecutors and Detective Zoeller have no notations of it. The prosecutor has no recollection of it, and the best the prosecutors can say is, well, if the witness said it must be true that she did say that during the interview. It seems to me that when a witness is interviewed on a prior occasion and does not mention something that might or might not be important in the case, and this seems to me as one of those things that is being magnified out of all significance, out of all proportion to what it really signifies. Really? How is this not a problem? He thinks this isn't an issue. But regardless of that, it seems to me that the witness should be subject to impeachment, that there is no notation and no documentation anywhere that would show that she ever said this on any other occasion before she testified in court. And that is the record. And it seems to me it could be brought out either by stipulation or by questioning of the witness that there is no record anywhere that she has ever said that this before saying it in court now. Ms. Towery says, I think that was done, Your Honor. And the problem is her response was that she did tell the prosecutors. Now Detective Zoeller tells us that he was out of the room during a portion of that interview. Now I'm faced with the prospect of calling Ms. Nahara and having Ms. Nahara say, I don't remember. Well, maybe she said it and maybe she didn't say it. The court says, as far as I'm concerned, that's a statement that she didn't say it. If she doesn't remember it being said, I think the inference is it wasn't said. I don't see how you can have it both ways by some such statement like that. Ms. Abramson says there's two different ills, if you will, Your Honor, that this ill illustrates is not clear which it is. One is a witness who continually makes up new information on her own, and another is a witness who makes up new information because the prosecution's suggesting that she do so, either by the way they question her or what they expose her to. And to say that this leads to impeachment of the witness if the prosecution is somehow at fault here or doing something wrong, we lose the opportunity to point out that if we're forced to take this position that the witness is making it up. I mean, this is not the only witness or the only example where people are taking the stand in this trial and we are hearing things for the first time. This sounds very familiar. This is happening in the Karen Reed trial as well. We're hearing things for the very first time that the prosecution clearly knows they're going to be saying because of the way they question them. And I don't know if it's because the prosecution's making it up and feeding it to the witnesses, which is a far more sinister view, or simply keeping things secret to surprise us, which is not fair. So either way, they're being blindsided and it's not right. To say our only resource is to impeach the witness when it may be the prosecution that needs impeaching, I don't think is adequate. I think before we concede what's going on here or try to reach any conclusions, we should take a look at the way the questioning occurred this morning or yesterday, and then we might have another idea of exactly The court says, that's fine. You could do that. You could do that. But at this point, my view is that either by stipulation or the court taking judicial notice, this witness never, on any other occasion, never said anything about this before. It's not documented or mentioned at any other time or place that she's ever said it before. The prosecutor saying she might have or might not have said it doesn't prove she might have said it before. Ms. Muir says, I have a note, Your Honor, just to bungle up the records even more. The only note I have, notes relating to prior statements that mention that, and I don't know where those, what's the word, cross-reference to. I just have a bunch of notes, but I don't have a note that says she stated this thing about the corn industry. That's a problem because I have a lot of notes that reflect a lot of information and I didn't put down who said what. So the court says all I can say is the record at this point is she didn't say it or you would have put it down. Ms. Towery says, Your Honor, if the court is not going to change its position on this issue, whether or not a leading question was asked by Ms. Nahara of the witness testimony, or the witness yesterday, then I would ask that the court take judicial notice of the fact that has never been said by the witness until she testified right after the lunch break, and so instruct the jury as a minimal sanction for the violation. The court said so she wants the court to say strike this. This was never or not necessarily strike it, but at least tell the jury like this has never been said before. This is the first time. This is stipulated to by both sides. Whatever. So something along those lines. The court says, okay, the people wish to be heard on that. Ms. Nahara says, I don't understand, Your Honor, what counsel feels we violated. She has brought out, the court says it's not a question of violation. It's just a question of trying to prove up the fact she never said it before. Ms. Nahara says, I understand what the court is saying. I can check the transcript when we have it. I believe she's gone over with this witness. Ms. Towery says, my other alternative, Your Honor, is to call Ms. Nahara to the stand and ask to see her notes. And I certainly don't want to be placed in that position, and I doubt that the court would permit me to do that, but she seems to be the only witness to this prior or lack of prior statement by Ms. Pisarcik. That was pretty brilliant. That was a smooth move by Terry Towery for Lyle. The court says, did you want to be heard further? Ms. Nahara says, no, Your Honor. I think, Mr. Khan, well, I think that it's fine if the court wants to take judicial notice. That's fine. I mean, I believe if the court doesn't desire to, it has already been brought out. The court says, well, her testimony is one thing, but proving it by some independent means is more probative than just her testimony since she would be impeaching herself if you take her testimony. She didn't see it in any report. She'd be impeaching herself rather than having it proved up by some independent language, which would be either by you taking the witness stand or stipulating to it, or the court taking judicial notice that there's never been any statement recorded of her that reflects that she's ever said this before. Mr. Khan says, we would ask that the court take judicial notice. Ms. Nahara says, right, that's fine. The court says, all right, we'll be in recess until 1:30. And just like that, we're back. And we're back with the jury. The court says, all right, the jury apparently is here in the jury room. So they're in the jury room. So they're not actually in the courtroom. So they're in the jury room waiting. Yeah, outside of the presence of the jury. All right, so he says, what did you want to talk about? Ms. Towery says nothing other than the reference in the transcript that the reporter provided to me. I showed to Ms. Nahara and provided the court with a copy of it, and that is the reference to Ms. Nahara's question regarding the corn discussion and the witness's testimony with Lyle Menendez, and the transcript does indicate that a leading question was asked by Ms. Nahara asking if that was discussed, to which an objection was made by me and the court sustained it, and therefore, after the testimony was elicited. I don't know what the page of the transcript is, Your Honor, since there's only that one copy. The court says 39 to 65. And what did you want me to do now that you've shown this to me? Well, Ms. Towery says the court had inquired as to exactly what had transpired and asked me to look into it, so I've done so. The court says it wasn't really my initial inquiry. Someone else brought it up as something that you wanted to deal with. Ms. Towery says, well, I do want that as part of the record of this entire issue of this discovery. The court says, again, it doesn't tell me whether or not the prosecutor knew about it beforehand unless that changes her recollection. Your position is anything changed? Ms. Nahara says, Your Honor, no. As I stated previously, I had noted of all the prior conversations of which that was a part of those notes, and I don't have a specific recollection that that was brought up at that time. I stated before it might have, but I didn't recall it. And I stated before that everything that we thought was different was placed in notes and highlighted. That's the best I can tell the court. The court says, all right, then why is it you won't stipulate to that? Why do you need me to take judicial notice of that? Ms. Nahara says, because I have a note on this. I just don't remember. I don't know where it came from, and if it came from her, I can't say it didn't. That's why I'm not stipulating to it. I can be wrong. The court says, well then, if it did, you should have turned it over to the defense. Ms. Nahara says, I know that. So either she violated discovery or uh, it didn't happen, basically, is where we're at. So the court needs to rectify this somehow. The court says, so do you want me to tell the jury that? Mr. Khan says, no, we're not asking the court to tell the jury that there's been a failure of discovery. It's my understanding the court was going to tell the jury that the statement that the witness gave here today was not previously recorded. The court says, right. Why can't you stipulate to that? Mr. Khan says, we'll stipulate to that. I guess Ms. Nahara didn't want to, but Mr. Khan was like, nope, we will. Ms. Towery says, I would ask that something further than that be done, Your Honor. Clearly, Ms. Nahara did not ask that leading question out of the blue, and she indicates that she must have talked to the witness about that, although it's unclear whether or not her notes of all these different conversations that the witness had with various people, which are all meshed together with her notes that were supposedly destroyed, reference Corn or not. So somehow she asked the leading question to get the answer to this. So she knew she was going to be going into this topic. So how did she know about this topic if she didn't put it in discovery? You know what I mean? Like if she knew about it, it should have been in discovery. So there's clearly some shady stuff going on here. Now, it's very clear that prior to this October 12th, 1995 conversation between the prosecutors and this witness who, oh, good, she's gone. She never said anything about Corn to anyone. She never testified about it. She never gave any such statement. Now, all of a sudden, Ms. Nahara yesterday in a leading question says, did he say anything about Corn? That didn't come out of the blue. It didn't just pop into her head while she's inquiring of the witness. So, but her position, since no discovery has been given to the defense, is that she doesn't recall. I would ask that it's put us in an impossible position, We can't impeach the witness because Detective Zoeller wasn't there. The court says you can impeach the witness by the fact that Ms. Abramson says the witness is telling the truth. It's Ms. Nahara who's lying. Oh, that's great. Ms. Nahara says, Your Honor, I'm going to ask that sanctions be deemed against Ms. Abramson for that comment, and I think she made it in court right now so that she wouldn't be sued for slander, and that is why she used the cover of this courtroom to do that. The court says, it's all very enlightening, but doesn't really move this trial along, these little outbursts one way or the other. That's good on him to be like, stop the bickering and just move on. You're asking me to make a finding, which I am not equipped to do based upon the information presented to me. You're saying, well, because the question was asked, I should then find that the prosecution knew this ahead of time. I can't do that. Ms. Towery says maybe the court can look at Ms. Nahira's notes in camera and make a determination whether or not her notes indicate a discussion about corn. If so, then clearly there was a discovery violation. We either have a discovery violation, in which case I would ask the court to instruct the jury as a sanction that that testimony by the witness is untrue. I would ask for this sanction. The other possibility is that the witness didn't say that to Ms. Nahira. Her notes don't reflect it. So the witness's testimony on the stand is untrue regarding her previous statement. If that's the case, then I'd ask the court to instruct the jury that she has never said that to anyone on the prosecution team prior to her testimony today. She never made that a prior consistent statement. Those are the only two possible scenarios. The court says, all right, it seems to me that the prosecution in its stipulation should go further than what it's proposing. That it's not just that this isn't in the notes, but that there was no evidence or information that she ever made this statement before. Mr. Khan says, all right, we'll stipulate to that. The court says, because that's really the most I can conclude from this, that there's no evidence that she ever said this before on any occasion. Now, as to why the prosecutor asked this question, I can't make a finding. It often happens during trials. Lawyers ask questions, and questions are often asked, especially on a subject such as this. Yeah, lawyers don't ask questions they don't know the answers to very often. So I highly doubt that she would have asked that without knowing that she was going to go into that. It wouldn't have hurt the prosecution if she said no. It wasn't as though the prosecution was going to lose something if she said no to the question about corn. It would have been that just would have been the answer. It's not as though the lawyer is asking a question and doesn't know the answer and are going to be hurt by it. Okay. So the question was asked and the answer was ultimately given. I can't make a finding from the sequence of events that the prosecution was willingly withholding material that should have been disclosed to the defense. Quite frankly, we've really consumed a lot of time over something that is not that significant an issue to start with. I think it's kind of a significant issue. I think you are covering for the prosecution, sir. You're focusing on a very minor point that doesn't deserve all this consumption of time. Ms. Taria says, well, Your Honor, I respectfully disagree with the court as to whether or not it's a minor point. That seems to be the central point of the prosecution's theory in this trial. The court says, what? Ms. Taria says, that is the mafia comments. The court says, well, the mafia comments came out beforehand. The only thing you're talking about is the corn. Ms. Towery says that's right, but that adds credibility to this witness's current version of what occurred, as opposed to her previous version of what occurred, where she wasn't even sure if she said mafia or mob. She said that was the impression that she got. The court says the record will now be that she has never said it before by stipulation, which impeaches her testimony. Ms. Towery says, and again, I would ask that the court take judicial notice not by stipulation, but that the court take judicial notice. The court says, I can't take that notice because I wasn't there. All I can do is take judicial notice of the facts that it's not in the reports. I can't go beyond that because I wasn't at the meeting and it's not an official record of anything that I'm lawfully entitled to take judicial notice of. Ms. Towery says the court can fashion a sanction in that way. Court says, I don't have to. There's going to be a stipulation that she never said it before. That's the prosecution's stipulation, which impeaches her testimony. All right, let's have the jury out. You may state the stipulation, Ms. Towery. All right, so it's good. The stipulation is good. They wanted more, but they didn't get it. The stipulation is important, though, so it's a good thing that they won on that. All right, so now the jury is back, court says, and the witness is on the witness stand. You may continue your examination or cross-examination. Ms. Tari says, thank you, Your Honor. I believe that we have a stipulation between the defense and the prosecution that the statement made by the witness regarding Lyle Menendez's comments about corn to her in connection with the supposed mafia conversation were never made by the witness to anyone prior to her testimony, including the prosecution team presently in court. Mr. Khan says, so stipulated, Your Honor. The court says, okay, that stipulation is noted, and the jury is to accept that as a fact, proven that the witness never said that on any previous occasion. All right. Your next question, please. Ms. Tari says, thank you, Your Honor. May I approach, Your Honor? Yes. I have a document containing what appears to be 2 checks, which was previously marked as Exhibit 381. I'd ask that it be marked Exhibit 157. Court says yes. Excuse me. Ms. Towery says, thank you. Cross-examination is resumed. Ms. Towery says, Ms. Pisarcik, do you recognize the documents which have been marked as Exhibit 157? Yes, I do. And what are those documents? Those are checks. Payable to whom? To myself. From whom? From Lyle. And what are the dates on the checks? Ms. Nair says, objection calls for hearsay. Overruled. December 10th, 1989 and December 19th, 1989. And what's the amount of the December 10th, 1989 check? One is just the December 10th, 1989, $700. And what does it say in the memo portion of the check? It says paycheck. Was that a check that Lyle Menendez gave you during the time period that you were living with him at the Marina City Club? Yes, it looks like it was. And the next document is also a check, isn't it? Correct. And that's payable to you as well. Yes, it is. And that's for $750. Is that correct? Yes. And that's also a check signed by Lyle Menendez. Is that right? Yes, it is. So I had to know what $750 was in today's money, and it's about $2,000. So there you go. He paid her about $4,000 in today's money in 2 weeks, it seems, or in a few weeks. Yeah, the 10th and the 19th, within 9 days. Correct, she says. And it's payable to you as well. Yes, $750. And that's also a check signed by Lyle Menendez. Is that right? Yes, it is. And that also is a check that he gave to you when you were living with him at the Marina City Club, correct? Yes. It doesn't say paycheck on it, but it is his signature. Were you an employee of Lyle Menendez during that time period? No. And you accepted those payments, did you not? Lyle, yes or no? Oh, yes. Now, in terms of the restaurant that you were giving him advice on, when did he buy that restaurant? I don't remember exactly, but it was after his parents' death. Was it after you left the Marina City Club? I don't remember. You didn't give him any advice about the restaurant until he bought it, did you? I'm sure if Lyle asked me anything about the restaurant, I gave him an opinion on what he should do. My question is, Ms. Nahara says, excuse me, Your Honor, I think the witness is trying to answer the question and was cut off. The court says, had you finished your answer? The witness said, no, I hadn't. Court says, you may continue. Ms. Tari says, I'd move to strike it as non-responsive. The court says, let's hear what the question was again. The question was read back as follows. You didn't give him any advice about the restaurant until he bought it, did you? The court says, all right, the answer was non-responsive. It is stricken. Ms. Tari continues, when you gave him advice about how to run the restaurant, that was after he bought the restaurant, wasn't it? Ms. Nahara says, objection, misstates the testimony and assumes a fact, not an evidence. The court says, well, let's get one fact at a time. Ms. Tari says, okay, we talked earlier about advice that you gave to Lyle Menendez about how much he should pay Erik Tam, correct? Correct. And how he shouldn't get taken by his friends in running the restaurant. Is that right? Right. And did you give him this advice before he bought the restaurant? I don't remember. When did you find out that he was interested in buying a restaurant? I'm sometime after his parents' death is when he started to pursue this. And you have no idea when that would have been. Well, considering the fact that his parents died in August and it was either September, October, November, December, January, or February before he was put into jail, I'm sure it was sometime during that time. Okay, if he didn't buy the restaurant until February, would it be likely that you would have been giving him advice about Eric Tam in October, November, December, or January? I don't know. Lyle and I could have had conversations about him wanting to buy it. I don't know. I really don't know. If you knew Eric Tam was under consideration for working at the restaurant, would that help you date when you gave him this advice? If you knew when Eric Tam was under consideration, do you know if that would help you? She says, yeah, it definitely would. So if Eric Tam did not become the manager of the restaurant until after Glenn Stevens ceased managing the restaurant, that would be after Lyle was in jail, wouldn't it? Yeah, it could have been. Again, I don't remember exactly when Glenn or Eric were partaking in this. When did you buy the Miata that you traded the Saab in for? I don't remember. I think it was Kramer Mazda, perhaps. Oh, where? Sorry, the question was where. Oh, my eyes are sucking right now. Sorry. Um, she says it was the Kramer Mazda, perhaps, but I'm not 100% sure. Was it a new Miata? Yes, it was. Or a used one. It was new. And Kramer Mazda is where? In Santa Monica? Objection, irrelevant, sustained. Do you have any paperwork that would indicate how much you got for the Saab when you traded it in? No, I certainly I don't currently have that Mazda anymore. So you sold the Mazda. Yes, I did. Do you remember the license number of it? No, I don't. Objection, irrelevant. Her answer is she doesn't remember. Now, during the time that you were Lyle Menendez's girlfriend, Lyle was closer to your family than you were to his. Is that correct? No, I wouldn't say that at all. Most of the time when Lyle visited, he visited my mom. He and my dad didn't really get along that well, but I usually visited both of his parents. Okay, and were you close to both of his parents? Objection, irrelevant, overruled. You can answer the question. The witness says, we did very many things together. Miss Towery says, and they liked you? I think so, yes. And they approved of your relationship with Lyle? Is that correct? Objection calls for speculation from the witness. Sustained. As best you could determine from your contacts with Mr. and Mrs. Menendez, they both approved of your going out with their son. Is that right? Objection calls for speculation. Sustained. You said that Lyle was very close to your mother. Objection, irrelevant, overruled. You can answer the question. The witness says, I don't know if he was very close. I mean, they had a normal boyfriends, kind of relationship. She was nice to him, he was nice to her, and it was, pretty normal, I guess I would have to say. And your mother still keeps in contact with him, doesn't she? Objection, irrelevant, overruled. I believe that my mother still contacts Lyle. Lyle continues to contact my mother. That makes me sad, but making me think that he was just looking for like a motherly, loving, motherly type figure in his life. Miss Towery says, and that's against her wishes? It's definitely against my wishes, she says. She doesn't like her and Lyle talking. My question was, is it against her wishes, to the best of your knowledge? You'd have to ask her. You testified at the last trial that Lyle contacts her against her wishes, didn't you? Yes, I probably did. And that was testimony that you gave in November of 1993, is that right? The last testimony. Is that about the time that you gave the testimony in November of 1993? I would assume so. Your Honor, I have a document that I'd ask to be marked as next in order 158. The court agrees, and it consists of an envelope containing a card. If I may approach the witness. The court says yes. Thank you. I'm showing you the document that I just marked, which is in an envelope with a card inside of it. To whom was the envelope addressed? Ms. Nahara says objection, calls for hearsay, overruled. Joseph Lyle Menendez. And what's the postmark on that envelope? Objection, calls for hearsay. Let me see the card, says the court, and the envelope, please. There's a pause in the proceedings. The court says, I'm going to sustain the objection on the grounds of 352. Let's move on to something else. Ms. Towery says, your mother continues to contact Lyle Menendez, doesn't she? Not that I'm aware of. Did you tell her not to talk to him? I didn't. Objection, irrelevant, sustained. The answer is stricken. Did you tell her when you testified, after you testified at the last trial, that you'd never speak to her again if she came in and contradicted the things that you said? Objection, irrelevant, overruled. Yes, please, let's learn more about this. The witness says no. Ms. Towery says, was your mother prepared to come in and testify at the last trial? Objection, calls for speculation, sustained. Did you believe that your mother was going to come in and testify at the last trial to contradict things that you said? Objection, irrelevant. The court says, at what time did she believe that? Ms. Towery says, after you testified at the last trial. Overruled. You can answer the question. The witness says, it did come to my attention that my mother had intentions of coming out here to testify, not to contradict anything that I said. Did you tell her not to? Objection, irrelevant, overruled. You can answer the question. My sisters told her not to. Oh, okay, so that's the distinction. Her sisters said not to, not her. Ms. Towery says, and that was, did you tell her that you wouldn't speak to her again if she came out here and testified? Objection, irrelevant, not irrelevant, overruled. You can answer the question. The witness says no. Now, many of the things that occurred that you've testified about in this trial and the last trial, you told your mother about, didn't you? Objection, irrelevant, overruled. Not a lot of things, no. And your mother is very ill at the present, isn't she? Yes, she is. After Lyle was arrested and after Ms. Nahara says objection to the form of the question, overruled. Ms. Towery says, do you need a break? It's okay. We can stop if you don't feel able to answer questions. The witness says, I'd like a break, please. Court says, okay, we'll take a recess until approximately 2:30. A recess is taken from 2:18 to 2:35. The court says, all right, the jury is not here, something counsel wants to talk about. So no jury, and Ms. Towery wants to uh, have some arguments about some of the things she's going to go back to. So she says, yes, Your Honor, the witness is still present. I'd ask that she step out. Court says, okay. The witness exited the courtroom. Ms. Towery says, I'd ask permission to go back into the document, which has been marked as Exhibit 158, which I'll indicate for the record is a card in an envelope addressed to Lyle Menendez in jail from Pittsburgh, Pennsylvania, with a postmark of December 1994. It's a Christmas card signed by Donna stating, I hope and pray that you have a wonderful 1995. Love, Donna. And in handwriting, I believe that the witness will recognize her mother's handwriting. The mother's name is Donna Pisarcik. And given her denial of her mother's contacts with Lyle, Lyle Menendez, her indication that that was against her wishes and her denial that her mother was prepared to come to the last trial to testify to contradict her, rather implying that she was coming to testify to support her testimony. I think I should be permitted to impeach her with this document. The court says, well, number one, it doesn't impeach, and if it did impeach, it's on a highly collateral issue. Ms. Tari says, I don't intend to ask her any questions about it, Your Honor. The court says, I understand that. My view is it's irrelevant and way off there in Neverland here with the examination going off into very remote issues. And you've asked questions as to her mother's state of mind, asking the witness to read her mother's state of mind, things of that sort. And at this point, my view is that you covered the territory as much as you should be permitted. Ms. Towery says, Your Honor, I need to ask two follow-up questions with respect to her understanding of her mother's intentions to come to testify at the previous trial. She has indicated that she was aware of that, and her sisters told her mother not to. And she has said in her testimony that her mother was not coming to contradict her. I do need to ask her if she's aware her mother was coming at the request of Lyle's attorney, Ms. Lansing. The court says it would be, Ms. Towery says, otherwise, there's an inference from her answer that's wrong, and I need to follow up on that and show that that's not wrong. Court says, look, you got yourself into this by asking these questions. You wanted to impeach this witness with what someone else might or might not have been prepared to do 2 years ago and ask her to read that person's mind and ask her what she would say in court. It's all irrelevant. It's not irrelevant if they had a conversation about it and if she knew about her mother's intentions of going to court and contradicting her. It's not irrelevant. Why is he being such a weasel, this judge? I don't like him. All right. So Ms. Towery says her mother still may be able to, and the court says call her in. Ms. Towery says, I may seek to do that or may seek to try to have an examination of her in Pittsburgh. She has very many contradictory things to say with respect to this witness's testimony. The court says fine. Ms. Towery says, it seems that the court is precluding proper cross-examination with respect to prior inconsistent statements by this witness. The court says no. Ms. Abramson says there's another aspect. The court says, first of all, this is only a witness by Lyle Menendez, and Ms. Towery is addressing the court. I don't see this as improper impeachment. And so basically, he's saying, Ms. Abramson, shut up. He loves to do that whenever he can. He says, I don't see this as proper impeachment, and I don't see this as proper cross-examination, and showing her this card and asking further questions along these lines is irrelevant. What is it that you want to ask? What questions, what answers would this other person have impeached this witness about? What is the proof? What does it possibly prove other than it's a waste of time? Maybe it's a waste of time to you, Judge, but it's not a waste of time to, say the defendants and the fact that their life is on the line. So it's probably not a waste of time to get to the bottom of this stuff. Ms. Towery says it can prove that this witness is not being truthful in her testimony. Court says, about what? Are you serious? Ms. Towery says that she made prior inconsistent statements about things she's testified. The court says, like what? That there are a number of things. I haven't asked her some questions yet. The court says, so you're trying to impeach her with what her mother would have said if she came into court in 93 or 94. Ms. Towery says, no. That goes to her bias and the fact that she did not want her mother to come in and contradict anything she said. The court says, all right, you've already got in the record as to her answers, and I'm foreclosing any further inquiry. I don't think it's proper impeachment of this witness. You made your record. Ms. Towery says, to protect the record, I think I have to say one more thing, and this is I have to move to strike the entire testimony of this witness based on the denial to confront and cross-examine. The court says, you've been more than amply given ample opportunity to confront and cross-examine this witness. It's been going on for a long time. I've given you a lot of leeway in that regard, primarily because the prosecution went into an entire time frame which opened this witness up to an examination that covered a longer time frame than I had anticipated when the people indicated they were calling her for one limited purpose, having to do with a conversation in the jail. And then from that, we had a life history of a relationship between these two individuals, which then exposed her to cross examination, which I've allowed over objections by the prosecution. As far as this particular inquiry, I don't think it's proper cross examination or fruitful or appropriate impeachment. All right, anything else you want to talk about? Ms. Tari says no. The court says, okay, how much longer do you think you have on this witness? She says probably about 45 more minutes. The court says, okay, let's get the witness in and the jury. And both entered, and we're back. The court says, all right, the jury is back. We'll continue with, hold on one second. We have one missing. You may continue your cross-examination, he says to Ms. Towery. She says, thank you, Your Honor. After Lyle Menendez was arrested, he, at some point, returned the engagement ring that he had given you previously. Is that right? After he was arrested? Right. Yes, that's correct. And do you remember when that was? It was around Sweetest Day, which would have to have been in October, so maybe 6 months or so after he was put in jail. In October of 1990? Yes. And what is Sweetest Day? I think it's a kind of a one of those Hallmark card days or Hallmark holidays. Okay, in October. Now, when Lyle Menendez gave you the ring back, he asked you to wear it? Yes, he did. And you did? Yes. And you also gave someone named Father Ken a gold ring for Lyle to wear, didn't you? I guess I did. You asked Father Ken to give it to Lyle to wear. Is that right? Objection irrelevant. Overruled. Yeah, I guess. I didn't remember until you just stated that. Who was Father Ken? Objection irrelevant. Overruled. You can answer the question. The witness says Father Ken was a priest that the family had known in the Calabasas area. And he visited Lyle in jail. Is that right? Objection calls for speculation. Overruled. I think several times. I'm not sure how often. Objection, motion to strike, no foundation. Overruled, the answer will stand. And after you received this ring from Lyle Menendez, did you plan to marry him? Lyle and I had talked about at some point when he got out of jail to get married. And we were hoping. And you wrote him a letter when he was in jail describing the wedding day that you would be having. Is that right? Objection, irrelevant. Overruled. Well, it was more of the dreams that I had. I'm sorry? I didn't hear what you said. It was more of the dreams that I had that someday, hopefully, we would have a wedding like that. Plans, we obviously couldn't make any plans. Your Honor, I have a document that was previously marked Exhibit 378. I'd asked that it be marked 159. The court agrees and asks to approach. He says yes. Showing you another document that looks like a letter. Do you recognize that document? Yeah. And that's a letter from you to Lyle while he was in jail. Yes, it's dated May of 1990. And in that letter, you describe the wedding that you hope to have with Lyle when he's released. Is that right? Objection, hearsay as to the content of the letter. Overruled. You can answer the question. The witness says, yeah, I obviously didn't read all of it right now, but it looks like a letter that I had sent to Lyle about talking about it. Ms. Towery says, do you want to read it? Okay. The witness does, and then she says, okay. And in the letter, you describe the wedding plans that you look forward to, right? Yes, again, they weren't plans. A church was never contracted, a priest was never asked to officiate, nothing like that. They were dreams. In that letter, it also states that Lyle had written of the same plans or dreams. And you wrote in the letter that you wanted Father Ken as the priest at the wedding, didn't you? Mm-hmm. And that was your feeling at the time, is that correct? Yes. Now, when you first got the ring back, did Lyle give it to you or did someone else give it to you? I believe Terry Baralt gave it to me. And thereafter, did you go down to the jail and visit Lyle? Objection irrelevant. Overruled, you can answer the question. Well, as I've stated before, I went down there most every day, so I'm sure I did. After you received the ring from Terry Baralt, did you take the ring with you to the jail? Well, after I received it, I probably wore it. All right. When you went to the jail to see Lyle the next time after you got the ring from Terry Baralt, did you tell Lyle that he was to get down on his knee and propose to you properly while at the jail? No, I don't remember doing that. You never said that? I don't remember, no, saying that. Okay. Do you recall when you did go see him, Lyle, when you did go see Lyle the next time after you received the ring from Terry Baralt that your mother was present? My mom was visiting for a period of time. I don't recall her being there at that time, but she was there in California for about a month visiting me. What month? I don't remember exactly. Was a fellow named Tim Custer present when you discussed having received the ring with Lyle at the jail? Ms. Nahara says, I'd object as irrelevant and also under 352. The court says, it's unclear what you mean by the question. Ms. Towery says, let me ask another question. Did you discuss with Lyle Menendez the fact that Terry Baralt had given you this ring to wear when you went to visit him at the jail? Well, I'm sure that Terry didn't just give me the ring, it was under Lyle's direction. Okay, my question is, did you discuss it with Lyle at the jail? I don't remember. You don't remember if you ever said anything to him about Terry giving me this ring? Well, I'm sure that happened, but I don't recall exactly what was said or, the conversation. But obviously, he gave me the ring. I'm sure I was very excited, but again, I don't remember. Come on. I don't buy it. Did you tell Tim Custer? Who is Tim Custer? Do you know who that is? Objection. I'm going to object irrelevant and also 352. The court overrules it. The witness says, I remember meeting Mr. Custer, but I really don't know if he was a family friend or how he knew Lyle or anything like that. Ms. Towery says, okay. Did you tell Tim Custer that you had, after you received the ring from Terry Baralt and went to the jail to see Lyle, did you tell Tim Custer at the jail that you had, oh, sorry, we had mail delivered and my dog, who I thought was sound asleep in her nap, decided that she was not. Maybe it scared her, I don't know. But anyway, sorry, let me back up. After you received the ring from Terry Baralt and went to the jail to see Lyle, did you tell Tim Custer at the jail that you had told Lyle that he was to get down on one knee and present the ring to you properly? Did you tell him that? Ms. Nahara objects, overruled, and she says, no, I don't remember saying that. Yeah, right. Ms. Tari says, and did you tell him, Tim Custer, that Lyle was seen by other inmates and they teased him about it when you made him get down on one knee? No, I don't remember that either. So it didn't happen. I don't remember it happening. And you don't remember that your mother was present as well when you made these statements to Tim Custer. Is that right? Objection, argumentative, sustained. Was your mother present as well when you strike that? Was your mother present at any time that Tim Custer was present at the jail when you went to see Lyle? Objection irrelevant, overruled. Sorry, I don't remember. It was a long time ago. Do you still have the ring that was given to you? No, I do not. And what happened to it? Along with everything else that Lyle gave me, I got rid of it. Wow. And how did you get rid of it? Well, I, on two different occasions, tried to return it to him, and he stated that it was a ring that he had made for me and that he did not want it back. I didn't have to, I didn't want to have anything to do with it, and I sold it. You sold it? Yes, I did. And that was at some point after you broke up with him in January of 1991? Yes. And several of the stones had been lost, but the part of it, I sold the remaining stones. And you kept the money. Is that right? Yes, I did. Now, you talked about Lyle Menendez in December of 1990 holding up a letter for you to read in the jail. Is that right? Yes. And that was something that Lyle did when you visited him, and there was something sensitive that you wanted to discuss. Is that correct? Well, Lyle, on previous occasions, if there was something sensitive, this is one way he would communicate to me. Yes, by writing something down and then holding it up or having it pre written before he had come down. And that was because you didn't want to talk about it over the phones that they had at the jail. Correct. And just so that the jury understands, you do have a piece of glass between you. Is that right? Yes, there's a piece of glass and you're communicating by telephone. And in that letter, Lyle told you that he had killed his parents. Is that right? Yes. And he also wrote in that letter that the reason was that Erik was being essayed by Mr. Menendez, didn't he? Yes. And also that Lyle was being essayed by Mrs. Menendez. Is that right? Correct. And the letter also said, "You don't know what I've been through," didn't it? I don't actually remember that part of it, but it was a very long letter. Did you remember that part of when you talked to the prosecutors and Detective Zoeller last week? I don't recall. Did you tell them that the letter what did you tell them that the letter said, "You don't know what I've been through," when you spoke with them on October 12th, 1995? I don't remember. I could have. I don't remember. And you didn't read the whole letter, is that correct? No, because Lyle, when it got to the point where he said about his mother essaying him, I stopped and said that I didn't believe this. I had never seen anything like this of his mother towards him and that I just didn't believe it. And, well, that's fine that you don't believe it, but that doesn't make it not true. And did he know you were at that point? Where were you reading out loud? It was pretty much, it was very easy to follow. And I stopped and I said, I don't believe what. Wasn't he holding it up to the glass? Objection. I don't believe the witness had finished her answer. The court says, "Why don't you finish your answer?" She says, "Thank you. I just said that I don't believe that your mother essayed you." Ms. Towery says, "My question is, how did you know that you got, how did he know that you got to that part? He was holding it up to the glass and you were reading it, correct?" Correct. Were you reading it out loud so he knew at what part you were at? No, I was not reading it out loud. So you said, "I don't believe you," and that's when he took the letter down. Is that correct? Yes. And there were more pages to the letter that you didn't read. Is that right? Yes. Did you read anything in the part that you did? Did you read anything in the part that you did read about Lyle and Erik Menendez being afraid that their parents would take their lives? No. Did you read anything in the portion that you did read about Lyle being afraid because the father would take his life because Lyle had threatened to reveal the essay about his brother if it didn't stop? No. So you don't know if the letter said that or not because you didn't read it all. Is that correct? Correct. But you do recall asking Lyle, "Why didn't you run away?" Is that right? Yes. And did you ask him that because he told you that he was afraid? No. I asked him that because it came to the point where I was very upset. Obviously, I was crying and asked him, "Why did you do this? How in the world could you take your parents' lives?" And that's when I said, I think I asked him, "Why didn't you just run away if it was so bad?" And he say that he wanted to. I think that's a typo here. And he said that he wanted to and he tried to, but Erik didn't want to. Is that correct? Yes, that's correct. Now, you said you were crying. I was obviously in shock and upset. What about Lyle Menendez? Lyle was upset too. Was he crying? Yes. And when you told Lyle that you didn't believe him about the essay and he took the letter down, didn't he say to you, "I didn't think you would believe me"? I'm not quite sure. You're not sure about that? What exactly happened? There was a lot of crying, and shortly after the deputies again came and took him away, we weren't down there for much longer than that. My question to you is, after he took the letter down, didn't he say, "I didn't think you would believe me"? He could have said that. Didn't you tell the prosecutors and Detective Zoeller on October 12th, 1995, that Lyle Menendez said that? If it's testimony, I obviously did. No, I'm asking you what you told them when you met with them a couple of weeks ago. Yes, I guess I did. Did you tell them that? I must have, yes. Do you remember telling them that? Yes. So you do remember telling them that? Yes. And then both of you cried for a while, is that right? Well, like I said, it wasn't too much longer before the deputies came down and took him back. Was it about 10 to 20 minutes? It probably was closer to about 10 minutes. Did you tell Ms. Bazanich and Mr. Kuriyama and Detective Zoller in your taped sworn statement in 1992 that it was 10 to 20 minutes? I really don't have the testimony in front of me, so I really can't remember. Ms. Tari says, "I can't locate it right now. I'll come back to that." Now, before Lyle held the letter up that told you that he had taken his parents' lives, had anyone else ever told you that Lyle had admitted to taking his parents' lives? Ms. Nahara says, "I'd object, Your Honor, calling for hearsay, and also I'd object to the use of the first name of the defendant. Sustained on both grounds." Ms. Nahara says, "Thank you, Your Honor." Ms. Towery says, "Was the time that Lyle Menendez held the letter up to you in the jail that told you that he had taken his parents' lives the first time that you were ever aware that Lyle had admitted to doing this?" I would think so, yeah. Well, is that your recollection? Yes. And you were shocked, weren't you? Yes. And that was in December of 1990, correct? I believe so, around that time. And he told you that the reason that he had never told you before was because you had never asked. Isn't that correct? Yeah. And he said that he was very sorry. Is that right? That's how the letter actually started, was that he was sorry that he had to lie to me for 10 months as I continued to come down and support him for his innocence. You never asked him before that time because you never believed he could do anything like that. Isn't that correct? I didn't think I had to ask him. And even after he held the letter up, you still didn't believe that he had done it. Isn't that right? I kind of went through a denial that he couldn't have done it, and he's just saying this as part of his defense. So part of me wanted to believe very much that he couldn't have done this. And the reason that you thought that he couldn't have done this was because he was someone that you were engaged to. Isn't that right? Yes. And you had plans to marry. Is that right? Correct. And he had been generous with you. Is that right? Yes. And he was someone who was very emotional with you. Is that right? Well, we objection vague as to time. Overruled. Could you repeat it, please? Ms. Tower says he was someone who was very emotional with you. Is that right? Emotional at different times. I mean, not, I guess, I don't really understand what you mean by emotional. Ms. Nahara says, I'm going to object, Your Honor, to this exhibit. The court says, all right, are you asking to mark that as an exhibit? Ms. Tari says, yes. The court says, okay, marked as 160. What did you propose to do with it? Just show it to the witness and see if it refreshes her recollection? Ms. Tari says, yes, Your Honor. Court says, all right, you may do that. Pause in proceedings. Ms. Tari says, may I approach? The court says, yes. Ms. Towery says, Ms. Pisarcik, showing you the document that's been marked for identification as Exhibit 160, I'll ask you to have a look at this document and see if you recognize it. Ms. Towery says, have you had a chance to look it through? Mm-hmm. Is that a letter that you wrote to Lyle Menendez? Yes. Is that a letter that you wrote to him while he was in jail? Correct. And does that refresh your recollection regarding whether or not Lyle Menendez was emotional with you? Ms. Nahara says, Your Honor, I'd object that it's vague. As to time, it's also irrelevant whether or not he was emotional. Sustained. Ms. Towery says, part of the reason you didn't believe that he could do this was because of your relationship with him. Is that right? I can't believe anybody would do this. That's your answer? Yeah. So whoever told you they had taken someone's life, you would disbelieve them, anyone in the world. I can't believe that anyone would take their parents' lives. I find that hard to comprehend. Okay, well, maybe if you would have continued reading Lyle's letter and didn't call him a liar outright, maybe you would have understood, but whatever. Okay, and it had nothing to do, your disbelief had nothing to do with your relationship with Lyle Menendez. Is that right? Well, I obviously had a relationship with Lyle and couldn't believe that he could do this. So you didn't believe that he personally could do this. Is that right? Yes, that is correct. And again, that was because you knew him. Is that right? Objection asked and answered. Overruled. You can answer the question. The witness says, as I stated, I couldn't believe Lyle or anybody could commit a crime like that. Ms. Tari says, you never said that you didn't believe someone else could commit a crime like that, have you? Going to object. This is relevant. Sustained. Didn't you tell the deputy district attorneys when you were asked about this statement that Lyle Menendez had made to you that the reason you never went to the police and told them he had admitted it was in part that you just couldn't believe it? Is that right? I'm going to object as irrelevant. Overruled. You can answer the question. As I stated, I went through a period of shock. The court says she just asked you whether or not you said that. That's all. The witness says, I don't remember. Yeah, answer the question that's being asked. Ms. Towery says, may I approach the witness, Your Honor? Yes. Ms. Nahara says, counsel, are you referring to a particular line? Ms. Towery says, lines 10 through 21 at page 64 of the sworn statement. Lines 10 to what? 21. Does reviewing this statement refresh your recollection regarding your state of mind in part as to the reason you didn't tell the police that Lyle Menendez had admitted to taking his parents' lives, that you were going through, or that he was going through a period of denial? Yeah, you were going through a period, sorry, that you were going through a period of denial and you couldn't believe that he had done that. Is that right? Yes. Now, after he told you this, you broke up with him, correct? Shortly after, yes. And you were also seeing someone else at the time, weren't you? Objection, irrelevant. No, no, it's not irrelevant. Overruled. You can answer the question. The witness says, no, not at the time, not until after I had broken up with Lyle and stopped, seeing him. Stopped seeing him at the jail? Yeah, I mean, there was a period of time, I would say, I think it was January that I stopped going down there. And did you tell Ms. Bazanich and Mr. Kuriyama when you talked to them in 92 that you had been seeing somebody else prior to the time that you officially broke up with him? Ms. Nahara says, Your Honor, if counsel is referring to something, could I have a page and cite? Ms. Towery says, page 40. Did you tell them that? Ms. Nahara says, can I have the line? Ms. Towery says, I'm not impeaching her yet, Your Honor. I haven't asked the foundational question. Court says, do you recall saying that? The witness says, can you repeat that? I'm sorry. Ms. Towery says, did you tell Ms. Bozanich and Mr. Koriyama that you were seeing someone else prior to the time that you officially broke up with Lyle in January of 1990? Well, after I had, the court says, no, no, just did you say that? Yes or no? If you don't remember, say you don't remember. The witness says, I'm going to have to say I don't remember. Ms. Towery says, reading from the transcript, if I may, Your Honor, the sworn statement, page 40, lines 4 through 13. Ms. Nahara, of course, objects. She says she doesn't believe it's inconsistent, and the court says, overruled, you can read it. Ms. Towery says, thank you, Your Honor. The question is, and how long after this conversation would you say it was? Answer, sometime in early January, early to mid January. Question, not long after? Answer, right. Now, when I say cease my contact, I officially broke up with him, saying that, I'm seeing somebody else, and I had been seeing somebody else prior to that, and that, I didn't want to see him anymore, although I did go down to the jail. Ms. Nahara says, and I'd object. I believe there's an insertion of an I, and I had. And I believe it's just had been seeing. Ms. Towery says, shall I read it again? Ms. Nahara says, I believe the line starting on. Ms. Towery says, I'll read the entire answer. Answer, right. Now, when I say cease my contact, I officially broke up with him, saying that, I'm seeing somebody else and had been seeing somebody else prior to that, and that, I didn't want to see him anymore, although I did go down to the jail. Um, And the person that you were seeing, at least after you broke up with Lyle Menendez, according to your testimony today, was that the same fellow who helped you move to the Calabasas house when you moved from Beverly Hills to Calabasas? Ms. Nahara says, I'm going to object, assumes a fact, not an evidence, that she was seeing somebody. The court says sustained. Ms. Towery says, you did see someone after the breakup of Lyle Menendez, didn't you? Yes. And that was the same gentleman who helped you move to the Calabasas house from the Beverly Hills house, wasn't it? Objection, irrelevant. Overruled. You can answer the question. The witness says, yes, and that person is my husband today. Alrighty then. Ms. Tari says, so you married that gentleman? Yes, I did. Objection, irrelevant. Overruled. The answer will stand. Miss Towery says, did you tell your parents that Lyle Menendez had admitted to the homicides of his parents after he told you that at the jail? Yes. I'm going to object as irrelevant and also call for hearsay, says Ms. Nahara. The court says, sustained on grounds of relevancy, the answer is stricken. Ms. Towery says, now, before Lyle Menendez told you that he had taken his parents' lives, you thought that it wouldn't be very long before things were cleared up and Lyle would be released. Is that right? Before Lyle had told me that. Yes. Yes, I was obviously very hopeful. And you thought that would be taken would be taken care of. I don't know why I'm like sorry, hold on, I'm struggling with this. And you thought that would be taken care of and he would be released from jail and you could go forward with your marriage plans. Is that right? Yes. And after he admitted to you that he had taken his parents' lives, you realized that he wasn't going to be released anytime soon. Isn't that right? So she was almost like waiting for him to get out. And then when she realized he wasn't getting out, bye, I'm going to go marry someone else. I'm pretty sure that's what happened. Um, I realized that he had lied to me for 10 months. And did you rely that he was not likely, did you rely that he was not likely to be released anytime soon when he told you to his parents? I don't know what that question is. Objection, Your Honor. Overruled. You can answer the question. I really don't think I was thinking about it at the time. Ms. Towery says, didn't occur to you at all? Like I said, I had been lied to for 10 months and I had been coming down to jail and supporting a person that I thought was 100% innocent. So you never thought about whether he would be released or not after he told you that he took his parents' lives. It didn't matter, she said. And you broke up with him. Is that right? Yes. And it didn't occur to you that perhaps he would not be inheriting any money when you found out that he had taken his parents' lives, did it? That never crossed my mind. Never crossed your mind? Never crossed my mind. Now, before Lyle Menendez admitted to you that he took his parents' lives, he had the conversation with you where he asked you to testify falsely. Is that right? Yes. And that conversation was over the phone. It wasn't by letter? I'm sorry, could you repeat which conversation? That conversation happened at the jail, didn't it? The conversation where he confessed to me that no, the conversation where he asked you to testify falsely. Oh, I'm sorry, yes. And when it occurred at the jail, he didn't hold the letter up and say, I want you to do this, did he? No, he may have written some things down, but it wasn't a pre-written letter like he had brought down that time. Have have you previously testified that the conversation occurred over the phone at the jail? Mm-hmm, yes. And you have previously so testified? I believe so. And when you gave your sworn statement to Ms. Bizanich, Mr. Kuriyama, and Detective Zoeller in November of 92, you told them about this conversation that you had, didn't you? Yes. And again, that statement was under oath, correct? Correct. And a reporter was present? Yes. And a tape player was there, is that right? Yes. And then when you testified in the trial of this matter, you again affirmed what what you had told the district attorneys and Detective Zoller in 92 under oath was correct. Is that right? Yes. Your Honor, I have a document that's been previously marked as Exhibit 248. I'd asked to mark it as Exhibit 161. Is that the next in order? The court says 161. Thank you, Your Honor. May I approach? The court says yes. Ms. Towery says, when you testified at the previous trial, you previewed the document that I'm showing you now, did you not? Let me read it. Okay. When you testified at the previous trial, you reviewed this document, didn't you? Yes. And you testified that it accurately stated the conversation that you had with Lyle Menendez at the jail in which he asked you to falsely testify. Is that right? Correct. And you had also reviewed the entirety of the statement that you gave under oath at different times for accuracy, had you not? Previous statements? Or previous statements? Sorry, that was not a question. Other than when you testified at trial about this particular portion of the statement, had you reviewed the entire statement that you gave for accuracy? Yes, I guess so. And when you testified here today on direct examination, you gave a version of what Lyle Menendez said to you when he asked you to give false testimony. Is that right? That is correct. And today you said that the two of you had seen the movie together, didn't you? We had. When did you see that movie together? I don't remember exactly, but we did see the movie together. Do you remember approximately when you saw it together? No, I think we rented it. Do you remember what city you were in? No. Do you remember if anyone else was present when you saw the movie together? No, I think it was just the two of us. Do you recall what environment you were in? Were you in someone's home? I think we were just in the living room, just watching the movie. I mean, it was a living room in some city where somewhere. It could have been in the Marina City Club. I really don't remember though. I just remember seeing the movie. And you remember what the movie was about, correct? Yes. And did you remember what the movie was about when you gave your statement in 1992? Yes. Did you remember what you had seen, or did you remember that you had seen it with Lyle Menendez? Yes. And why did you tell Ms. Bazanich and Mr. Kuriyama and Detective Zoeller and the jury at the previous trial that you hadn't seen the movie before, or you weren't sure if you had seen it? Objection misstates the testimony. Overruled. I did not state that. As a matter of fact, just in rereading this, I stuttered and corrected myself, saying that I had seen the movie, I just hadn't seen it after the first time. I had not reviewed the movie. Oh, that sounds even more guilty. Like I have not reviewed the movie, like I didn't review it before my prior testimony. Did you tell did you tell them you had seen it with Lyle Menendez? I don't remember if I stated that we had seen it together. I think it was just I had assumed that they knew that. What? And you saw that and you say that you told them that you had not seen the movie and then you stuttered and said that you had seen the movie when you talked to them? Well, what I was referring to in that statement was that I had seen the movie, but that I had not reviewed the movie since Lyle had asked me to lie. And the statement that you are referring to is the following. Question: and what happened in At Close Range? Answer: I had seen the movie before. I did not go home and watch it. I had not seen it, but in that movie, the father, I guess, makes passes, or I don't believe he R's the one character, the Sean Penn's girlfriend. He had asked me to say that that's what had happened. Was that what you said in 1992 to the deputy district attorneys and Detective Zoeller in your sworn statement? And as you can see, I was correcting myself. Your Honor, may the witness finish her answer? Ms. Nahira says, the court says she had. Ms. Towery says, she didn't even start talking again. Is that what you testified to at the last trial? I testified that I had seen the movie and that I had not re-seen it since the last time that Lyle and I saw it together. That's what I was trying to say. So you testified exactly to what is in this at this so you testified exactly to what is in this at the last trial, did you not? Yes. And now you are saying that you saw it with Lyle Menendez somewhere perhaps on video, is that right? Yes. Is it possible that you saw it at the theater? I remembered the movie. It was obviously a very violent movie. I don't exactly remember, but I think it was on video. Do you remember the movie at the time you talked to the deputy district attorneys and Detective Zoeller in 1992? That I had seen the movie? Yes. Did you remember the scene that you were talking about in which the father makes passes at, but you don't believe that he R's the one character, Sean Penn's girlfriend? I remembered the scene. When Lyle talked to me about the scene on that day, I knew exactly what he was referring to. I didn't remember it being as graphic as it was. All right. So you were describing for the deputy district, for Ms. Bazanich and Mr. Kuriyama and Detective Zoeller in your statement under oath that Lyle Menendez said to you on this day, or on that day. Is that right? Yes. And your description of what he asked you to do was that the father made a pass at you, or a pass. The father in the movie made a pass at Sean Penn's girlfriend. Is that right? Yes. And when you came in here and testified today, you told a story about a girlfriend in a room with the father, and the father had given the girl a pill, and that she was ultimately R'd by the father, etc., etc. Is that right? Yes, it is. Have you seen that movie since you spoke to the district attorneys and Detective Zoeller in 1992? I had seen it just several days ago, yesterday. I was asked to review that scene. I had seen it several days ago, she says, and then yesterday I was asked to review that scene. Okay, let me ask you another question. I will get to that. Okay, did between the time that you talked to Lyle Menendez and at the jail and the time that you gave this statement in 1992, did you review the movie? No, not. You mean after he had asked me to lie for him? From that time until yesterday, I had not seen the movie. So then you didn't see it before you gave the statement. Between the time he asked you to testify falsely and the time you gave the statement in 1992, you didn't watch it. Is that right? Correct. And you didn't watch it between the time you gave the statement in 92 until the time you testified in 93. Is that right? Correct. And you saw the entire movie. Did you say yesterday? No, not the entire movie, just did you watch part of the movie yesterday? Just that one scene. And who showed it to you? The prosecution did. And where did they show that to you? In the office. Did they pick out the scene to show you? There was several scenes kind of running together, but yeah, I mean, it started at a certain point. So you didn't look at the movie and say, this must have been the scene that he was referring to, did you? They asked me if that was the scene that he was referring to. Well, the scene that he was referring to, as you described it in 1992, was in that movie. The father, I guess, makes passes, or I don't believe he R's the one character, Sean Penn's girlfriend. He has asked me to say that's what had happened. That's what you said in 92, wasn't it? It was the same scene. How do you know it was the same scene? Lyle didn't show it to you before, did he? No, but Lyle talked about it and asked me to say that, and that was the scene that he was referring to. So he asked you to say that his father had R'd you. He had asked me to watch the movie again, which I did not do because I had remembered it. I had remembered the whole entire movie. And he had asked me to say that in the one scene that the father had come on to the girlfriend, if I would say the things that he did in the scene that Mr. Menendez had done to me. Okay. He never said, I want you to say Mr. Menendez R'd you, did he? He didn't say the word R. He said that scene. And you added that into what he said after you watched the clip that the prosecutors showed you in their office. Is that right? Well, that's the only scene in the whole movie where anything like that happens. My question to you my question is, you added that into what he said. He never said that, did he? The word R? The R word? Yes. No, that's what he implied is her answer. Well, your belief at the time was to the contrary, wasn't it? My belief at the time was that I hadn't seen the movie in a while and that I knew exactly what Lyle was talking about, and he was asking me to get up on the stand and say that his father had done something to me that he hadn't done. Okay. And I don't think he would say that it and I don't think he would say that it was shaking my hand. What? Okay, anyways. And you knew exactly what he was talking about. And what you thought he was talking about was what you told Ms. Bazanich, Mr. Kuriyama, and Detective Zoeller in your statement under oath and what you testified to at the last trial, right? Yes. Ms. Nahara objects. Ms. Towery says, now you also, by the way, there is no R that's shown in the actual film, is there? He throws her down on the bed and starts taking off her clothes, and you hear a very, very loud scream. So there is no R, is there? That's shown in the film. Objection argumentative, and actually the film speaks for itself. Overruled. Ms. Tari says, you just saw it, didn't you? Yes. And it doesn't show on the film the father character in the film, R-ing the girlfriend. Isn't that right? Your Honor, I would object and say the scene speaks for itself. The court says, I heard you say that, and the objection is overruled. The witness says, I think the scene spoke for itself. Oh my God. So because the attorney said that, now the witness says it? Are you kidding me? Ms. Terry says, so do you speak for yourself? I do. Your Honor, that's argumentative. Overruled. Overruled it. It is probably argumentative, but it was overruled. Um, maybe not. Ms. Terry says, so my question to you is, you just saw the scene, the prosecutor showed it to you, correct? Yes. And there is no R that's depicted in that film that you saw, is there? Well, yes or no, is there any R that takes place? I consider that R. Okay. So throwing her down on the bed and starting to tear her clothes off and a scream, that's what you consider R. Yeah. And that's what was shown on the film, correct? Yes. Now, you also said in your testimony today that after you refused and said you wouldn't do this, that I believe your testimony was that Lyle said, well, I figured. Court says, okay, let's refer to people by their full names. Ms. Harry says, I'm sorry. Lyle Menendez said, well, I figured you wouldn't go for this. Is that right? He did say that. And did you leave something out about what he said in your testimony this morning? Well, he stated that again that he was going to put a large sum of money in my bank account. No, I am asking you if you left something out when Lyle said, well, I figured you wouldn't go for this. Did you leave something out of that statement? If I did, it was inadvertently. Did Lyle Menendez say to you, that's what I thought you would say, and that's what I told Joel you would say? You would never do that. He did say that. That's what he said. Yes. And who is Joel? Objection calls for speculation. Sustained. Did you know who Joel was that he was referring to? Objection calls for speculation. Sustained. That's not speculation. Did Lyle Menendez tell you that there was a scene at close range where what they wanted you to say, he and his lawyer, which was Joel at the time, that he wanted you to watch? He didn't say that he and his lawyer wanted me to watch it. No, he said that he wanted me to watch it. He never said that. He didn't say that Joel and he wanted me to watch it. He specifically said that, he wanted me to watch it. Yeah. Reading from page 56, Ms. Towery says. Ms. Nahara says lines 24 through 28, and the following page, lines 1 through 2. When you made your statement to Ms. Bazanich and Mr. Kuriyama, which you subsequently adopted, Ms. Nahara says, Your Honor, I would object to that as hearsay the entire question and also calling for speculation on this witness's part as to the answer. Overruled. You made the following statement, didn't you? Quote, previous to or prior to him telling me that, holding the letter up, I guess he was kind of, working on his own defense type thing, and he had asked me to watch a movie called At Close Range, and that is what, in that movie, there was a scene where that is what they wanted me to say. He and his lawyer, which was Joel at the time, this is what Joel was saying. I've never spoken to Joel. Isn't that right? Ms. Nahara says, motion to strike any statement from anyone other than the defendant as hearsay. Overruled. Ms. Towery says, is that what you said? Well, what I said was that Lyle had asked me to do that, and then after the fact that I said no, I wouldn't, that's when he said, I didn't think you would do this, and that's when he stated that there was a Joel. But not prior to that fact, not prior to him asking me. Did you say what I just read in your statement under oath? I must have, yes. And you said it again at the last trial, didn't you? I guess so, yeah. And you knew to whom he was referring when he said Joel, didn't you? Ms. Nahara says, objection assumes a fact not in evidence. Court says, overruled. The witness says, I had never met a Joel. Ms. Towery says, you had no idea who Joel was at the time. Well, I knew that he was. Ms. Nahara says, I'm going to object, stating that it's irrelevant and also calls for hearsay. The court says, well, overruled on both of those two grounds. Ms. Nahara says, also calls for speculation of this witness. Sustained. Thank you. Ms. Towery says, well, you said Joel was his lawyer in 1992, didn't you? I don't know if he was ever a lawyer or he was going to be a lawyer. I, again, never actually met the man, so. Okay. Your words were, let me read it to you again. Ms. Nahara says, Your Honor, I would object to any reading of this. The witness there is no foundation for this answer. It's calling for speculation from the witness. Court says, well, except that it was her speculation at the time. So, overruled. Ms. Towery says, you said under oath 2 times previous that prior to him telling me that, writing, holding the letter up, I guess he was kind of, working on his own defense type thing, and he had asked me to watch a movie called At Close Range, and that is what in that movie there was a scene where that is what they wanted me to say. He and his lawyer, which is Joel at the time. Okay. And that's what you said, isn't it? Okay, yes. And you knew that his lawyer was Joel. Is that right? Did you make that up in 1992? No, I guess I don't know who Joel is. Have never met I have never seen him, so it's hard for me to think back and place the man with a face. I don't know who the man is, but I know there was a Joel. And you knew that Joel was Lyle's lawyer at that time, didn't you? Objection overruled. The witness says, I guess so. Miss Towery says, you said that 2 times under oath before now, didn't you? Ms. Nair says, I would object, no foundation. Overruled. Yes? Yes. Now, the occurrence where that you and Lyle discussed about you watching the movie and testifying that his father made a pass at you, right? That never, in fact, happened, did it? No. Mr. Menendez never did make a pass at you, did he? Never, never. To your knowledge, did he even like you? Objection, irrelevant, calls for speculation, overruled. I talked to him on the phone. He came and watched me play tennis. When we announced our engagement, he told me that he would like to have a party for us. Tari says, my question is, I don't believe she finished the answer, Ms. Nahara says. Motion to strike is non-responsive. Objection sustained. The answer is stricken. In regards to your relationship with Mr. Menendez, did he even like you? I thought he did. Objection. Ms. Towery says he talked. What's the objection? He liked you a lot? Objection irrelevant and calls for speculation. Overruled. You can answer the question. As far as I knew, Your Honor, I don't know if the court wants to take a break. I have one other area to go into that's going to take a little bit of time. The court says how much longer? I think about another half hour, 20 minutes. The court says, does the jury need a break? Anyone need a break? One person needs a break, so we will resume in 10 minutes. We will resume at 10 minutes to the hour, and we are actually going to stop here, and we will continue uh, this next week and continue right from where we left off. So thank you guys so much for watching. Let me know what you think of this testimony down below, and I will see you guys in the next one. Take care. Bye now.